16-53835. I'm sorry, let me start over. We are recalling case number D-16-538-315-S, Vanessa Loftis versus Burke Hall. Just so it's clear on the record, would you please restate your names and appearances?
Patrick Marsh, bar number 10162 on behalf of the school district.
Melvin Grimes, bar number 12972 on behalf of the plaintiff.
Burke Hall, there is no bar. I'm just pro per.
Representing yourself, Mr.
Yes,
Hall. All right, we are here on Mr. Hall's motion to compel records from the Clark County School District and specifically Katz Elementary School. We took a brief recess so that all of you could discuss the documents that were being requested. The school district had brought them to court today through their counsel and with an authorization for you to sign Mr. Hall. Have we been able to work through the issues, and are there any issues remaining for us to address?
There are some issues remaining for us to address. I have signed the documents that have been asked.
Wait, you signed the authorization that was presented to you by the Clark County School District?
Yes, ma'am.
And what did you receive in response to giving the school district that authorization?
He gave me some records that I have that are incomplete.
I can tell you what I gave
but
you.
Okay, I'm going to ask counsel to state, is it Murch?
Murch, yes.
Mr. Murch, would you please say, I'm terrible with names today.
That's fine.
Would you please state what you have provided to Mr. Hall as a result of the authorization he signed today here in court?
For both kids, I provided report cards.
Which kids do you?
Emmanuel Hall and Storm Hall.
Okay.
I provided report cards for prior years at both Katz Elementary and Rowe Elementary, depending on where they were in school, and for this year. I provided some testing information, test scores, attendance records. I provided a redacted copy of the parent contact sheet, the person summary report that we have, that does not have the mother's information.
What is redacted from that parent information sheet? What have you redacted?
The mother's address, mother's phone number, the mother's email.
Okay.
And any emergency contacts. I believe there was one listed for one of the kids, and there wasn't one listed for the other kid. But name, address, email, phone number for anyone who's listed as an emergency contact who's not the mother.
Okay. All right.
And that's in accordance with our standard practice that we don't provide that information. It's not considered an education record under FERPA, the Federal Education Records Act that governs the education records. So in addition to those things, I informed Mr. Hall that I will talk to student services to see if there is any, for one of the kids, I provided a Section 504 documentation. So
is that an IEP?
It's related to an IEP.
Okay.
It's not an IEP, but it is for special accommodations in education for somebody who doesn't qualify for an IEP but may need accommodations in certain areas. Provided that for one of the kids. It's my understanding that there may be additional information regarding psychological testing or a decrease in performance for one or both of the kids between Rowe and Katz. I don't have that information. It may be with our special ed department, student record services. One of them, I'm going to go back to my office after this and ask them for it. And I will also go back to my office and ask risk management for any health records.
Okay. All right. Mr. Hall, what is it that you believe is deficient?
What he said, I need to know, because I talked to the school psychologist. His name is Steve Idlings, and he's like the version of Miss Carter at Lewis E. Rowe. They're both school psychologists. And he's telling me that my son, in a meeting with him face to face, he said, your son was at 46%. We got him up to 46% when he's at Lewis E. Rowe.
46% of what?
46 percentile of his reading, his education. He is now down to 18%. Mom has him on drugs. He's falling asleep in the classroom, according to his teacher, according to the heavy drugs that they have him on. Mom is saying there's some medical issues that are going on here where the judge has authorized Mom to be able to drug Emmanuel, my younger son.
Okay, we're just talking about what records are you still looking to obtain from the school district that you believe they have? He's indicated he's going to get the counseling records, or
Yes.
I'm sorry, from the risk management, the medical records,
Now, when I
as well as the special education records.
Yes.
And will that also include, Mr. Murch, any other psychological testing from the school district or any of their schools?
I can ask for that. I don't know whether there is any,
Okay,
but I can ask for it. I'm
so if it's available, it is going to be produced to him, correct?
It's available and producible. There are certain things such as, just for example, counselor notes. The counselors kept separate notes on their own. Those are protected by privilege. We don't produce those. I don't know if there is also a school psychologist privilege. I believe there is. If there's records of communications with the kid, those are produced.
Okay.
But anything that is producible and constitutes an education record under FERPA, happy to get that stuff and produce it.
Okay,
The next thing is the other gentleman named Nathan Presley, that is Nathan Presley was the convicted felon that is authorized to somehow pick up my child. I want that unredacted record that he's on there so that I can address this with the judge.
okay. I am going to recommend that the parent information sheet with the name of the emergency contacts only be unredacted and produced to Mr. Hall. Addresses, phone numbers, and email addresses are not to be included, but
Just need a name.
just the name of any emergency contacts that have been indicated can pick up his children from the school.
Just for the record, I'm gonna object both here and at the time of trial to their admissibility as discovery is closed, so, I know.
You have the right to do that.
Your Honor, I've been trying to get this.
I understand.
For years.
You can make that argument to the judge at the time of the evidentiary hearing. I'm just going to allow I'm going to recommend that be produced to you. All right, how long do you need to have those documents produced to Mr. Hall?
Today is Wednesday. I can have them to him by no later than Friday.
Okay, and how would you like to receive those, Mr. Hall? By
Hard
email?
copy.
Hard copy?
I'll go pick them up from him.
I will have them in my office, and I will contact him and let him know when they're ready.
All right, so I'm gonna ask you to exchange information here in court of how you can, so that Mr. Murch can get a hold of you, Mr. Hall, to contact you and let you know those documents are available for you to pick up at his office. And where's your office located?
5100 West Sahara, Decatur.
I've been there a multiplicity of times over
Okay.
this issue.
Your Honor, I would ask that I receive a copy, only because I'm gonna be filing a motion in limine. I don't wanna waste trial time on it. I'm gonna file a motion in limine to preclude it. If I have the documents, it just makes it easier.
All right.
I'll get you mine now.
If you,
I don't need a hard copy.
Well, what I'm going to do is require Mr. Hall to produce a copy of everything that he receives from the school district to counsel for the defendant.
Yes.
give a date for that to be done so that.
That's even easier.
Okay, so you're going to receive the documents by Friday. I am going to, we don't have a trial date in this case, do we? A hearing
Yes,
date?
we do.
The 28th of January is coming up way too fast, Your Honor, for me to be able to go through these documents.
Why is it not on
I
there?
will, make it easier for everybody, I will give him 2 copies, and then he
All
can
right.
just contact, Mr. Burke.
He can do, and so you need to have those to counsel for the defendant by, you're gonna obtain them on Friday, so you need to have those delivered to counsel for the defendant by Wednesday. Next one.
The 23rd.
By January 23rd, at close of business.
January 23rd. That's up against the wall for me to be able to do anything about what I received.
Well,
Let's just give me a copy so I
You're
can
just
file
giving
my
him a
motion in
copy.
limine to preclude them.
you're getting the documents Friday in 2 days. You then have to take the extra copy that the school district's going to give you and deliver
Give
it
it
to
to
counsel for the
Axel,
defendant
yeah.
by next Wednesday. That gives you 3 days to get it done.
Yes, ma'am.
And then any other issues you have for not being prepared for trial, that's something that you need to take before the judge.
Yeah.
I am going to ask, counsel, would you prepare the report and recommendation?
You're kidding.
Okay.
Okay, I'll do it.
Otherwise, I
Your
just
Honor,
want it to be done.
I am gonna ask, there was no meet and confer, he is the movement, he is required by rule to attempt to resolve this, simply reissuing. I am going to ask for attorney's fees in the amount of $1,000.
But he wasn't issuing it to you. You technically don't really have a dog in the fight because you didn't object to the production of the documents. So you're not going to get attorney's fees and costs on this. If anything, that would be an issue for the school district to bring up. I'm going to ask Mr. Murch, would you please
I'm
prepare the
happy to
report
do
and
the report
recommendation?
recommendations. I've already let Mr. Hall know that we have the opportunity to object to that if we decide that you know.
Okay, I'm gonna
that
ask
name
Mr.
is-
Murch to
I'm
prepare.
happy to do that. The other issue is that there are additional subpoenas out there that are after this, that we may be back in here, that if they're not served, I have the right and still have not exercised the right to object to those subpoenas, just so Mr. Hall knows that there may be more objection letters coming.
Okay, have you requested any additional information from the school district for your children that we've not talked about here today? Cause since we're all
Yes.
here, we might as well try to resolve as much as possible.
Yes, there is.
And what is it?
My kids were at Lewis E. Rowe Elementary School for
Okay.
about a year. When my son was there, he was exhibiting some very odd behaviors, like he was chewing the entire front of his shirt until the entire front of his shirt was soaked with his own human saliva. He was also, the mom had him on a chewing necklace, and this was when Miss Hobson was there to witness this. Another thing that happened was he would,
I'm asking what records are you seeking to obtain?
not records, but I'm wanting the teachers to testify. And this is totally my fault, Your Honor, cause I'm pro per, I don't know, I'm not a lawyer, but I didn't know how much money I'm supposed to give on a subpoena. Because
Okay,
one's a principal.
you can address that downstairs in the self-help center?
That's what he graciously told me that.
Okay.
So that was another thing, we had another meeting with,
So any witnesses you're attempting to subpoena for trial, you
yes,
can go to the self-help center and ask for their assistance in
Yes.
helping you prepare and have, whatever they can help you with regarding the trial subpoenas. That's not a discovery subpoena, so that's
Yes.
not an issue properly before me.
so Your Honor, last but not least, I've already served the subpoenas. Is it possible that I can send the money to Clark County
That's something that you're gonna have to discuss
with
with
the people
Mr. Murch.
downstairs? Or do I have to
I've
research
already
it?
informed him that if it's a valid subpoena served, if it's a valid subpoena and it's validly served, our people will comply with it. If it's not, he's probably gonna get an objection from me.
Okay, if you receive an objection from Mr. Birch, then you can speak with the people at the self-help center to assist you in correcting the problems with your subpoenas
Yes.
and getting them issued properly. He's already indicated he's gonna object if they don't have a witness fee, so
Yeah.
perhaps you can forward I don't know if he will accept a late witness fee, but that's something that you and Mr. Birch can perhaps work out.
I need to speak to my boss and see what she says. My guess is that we're complying with the rules and we're gonna require it.
Redone, is that what you're saying?
Yes.
Okay, well, it sounds like he's gonna make you redo it, so that's something that you need
Let's
to
just
get.
do that. Let's just say that.
Okay, I'll just redo it.
Okay,
I'll resubmit it with the fee.
You're on, only because you are kind of like, well, maybe we could work out some of this other stuff. Most of the witnesses listed on the subpoena were not in this pretrial memorandum and have never been disclosed as a witness.
Okay.
Are you inclined to hear an oral motion to preclude any witness not previously disclosed during discovery? And
No.
save some time here.
Your
well, I
Honor,
think that is,
just hang on, Mr.
that-
Hall. Look at you.
that's an evidentiary issue before
Okay.
the judge.
That's fine.
Certainly, it sounds like you have solid grounds, but that is something that needs to be addressed before
Fine.
the judge, before Judge Pomeranz in this matter.
Just to let you know, Your Honor, these witnesses have been requested to show up 6 different times.
The
So-
requirements are that if you intend to
Yeah.
call a witness at the time of the evidentiary hearing, that they must be disclosed within the discovery period, either through your disclosures, or if it was someone that was identified in the opposing party's list of witnesses, you are also then would have a right to disclose them. But if they did not disclose these witnesses, and you didn't disclose these witnesses, then pursuant to the rules, the judge is probably not going to allow you to call the witnesses,
Well, I've
whether or
disclosed,
not you've subpoenaed them.
well, I've disclosed them in the past already, before he even got the case, he doesn't look through very much of the case, so.
Okay,
they've been
I'm just
disclosed.
telling you, I don't have all of that before me, and that's not an issue that we were here to discuss today.
You
But I'm
betcha.
telling you that if you have not properly disclosed witnesses, my inclination is, that's something that the judge will determine, but typically, witnesses who have not been disclosed during the discovery period to opposing parties cannot testify at the time of the evidentiary hearing. Okay?
Your Honor?
Yes?
Last but not least,
I just wanna say thank you so much. You're so helpful. For someone who's pro per like me, this is really scary and hard, and you make it so much easier. Thank you so very much. And thank you to council as well.
You're welcome, and I suggest that to address the issues that, on the subpoenas, that you seek help at the Self-Help Center.
You betcha.
Report and recommendations, I don't.
Due to, I'm
I
sorry.
don't get in discovery disputes, so I
Okay,
tend to work
you-
them out so we don't have to come in here. What,
You can get a draft copy upstairs on the third floor from Mary Brachon. It's
I
a-
already have the form, I just need to know.
Oh, I'm sorry.
What's the timeline? Is it
Oh,
10
I'm sorry, I
days?
apologize. 2 weeks from today
Okay,
is when I'm sending the status check, so that is January 30th at 2 p.m. is a submission for this, is a status check on the submission of the report and recommendations. If I receive them from you on January 28th at 5 p.m., I will vacate that status check hearing, and you won't need to appear.
And I will waive review and signature.
Okay.
okay.
Would you like to review and sign the report and recommendation?
Yes, Your Honor. What happens to my trial on the 28th? Is that pushed forward?
No,
Nope.
That stays the same.
Okay.
that stays the same.
Okay.
But he's giving you an opportunity to review, you have an opportunity to review and sign the report and recommendations. It's due 2 weeks, or, January 28th.
I'll get it to him before that.
Okay, all right.
Okay.
Thank you all.
Thank you.
Your Honor.